Committee's work spanned 21st March 2025 to 30th April 2025. It received 43 reports from institutions and individual petitioners. Of the 43 institutions, 36 appeared before the committee. At the end of its work, the committee made the following findings. 1. Of the 36 institutions that appeared before it, 28 had commenced the recruitment processes before the 7th December elections. 2. A total of 13 institutions revoked appointments made in a response to the 7th of December 2024 Revocation Directive. 17 institutions did not revoke their appointments but sought guidance from the Office of the President. 16 of the cases reported by the institutions were mainly payroll related. In total, there were 2,080 recruitments, appointments, and promotions that were reported by institutions when they appeared before the committee. Now, out of the 2,080 recruitments, appointments, and promotions, 879 were revoked by the institutions themselves, while 1,201 appointments were left unrevoked. After the hearings, the committee recommended that 1,539 of the recruitments, appointments, and promotions be upheld because they complied with the prescribed recruitment and promotion procedures and received appointment letters before 7 December 2024. And this also implies that they achieved a pass mark of above 80%. The committee recommended, however, that the recruitments, appointments, and promotions of 541 persons be revoked because the recruitment processes ended after 7th December 2024 and failed to meet the pass mark. In other words, they also did not comply with the processes and guidelines slated or designed to govern that process. Also, the number of recruitments, appointments, and promotions recommended for revocation by the committee was lower than the number that the institutions themselves revoked in the wake of the Chief of Staff's directive. As I indicated, the number was 879 in all. That's the number of recruitments, promotions, and appointments that were revoked. Now, this differential is because the committee paid special attention to vulnerable groups, including persons with disabilities, particularly within the Ghana Education Service. There were some of our compatriots who suffered some disability, but we found that their recruitments should be revoked because it did not comply with the laid down process. But because of their peculiar situation and the hardship that could be imposed upon them if we were to enforce this directive, they were given some clemency, and therefore they have been allowed to regularize their processes in order that they stay within the public service and earn an income.
The terms of reference for the committee, number one, that they were to determine whether the prescribed procedures for recruitment and promotions were followed in the recruitment and promotions made after 7 December 2024. Establish the dates on which the process leading to these recruitments and promotions commenced and ended. 3, identify and categorize recruitments and promotions that complied with the stipulated procedures and those that did not. And 4, provide case-by-case recommendations for government's consideration. Why did this committee become necessary?
Well, I think that the committee was a reflection of government's desire to be fair and not to impose undue hardship on persons who had not committed any offense. What had happened, Samson, I'm sure you followed the post-election transition closely. So on the very first day of our first meeting, it came to light that some significant recruitments were happening in the aftermath of the elections. And also some significant monies were being paid to government contractors and other creditors. So the incoming government side of the transition requested a note because of the time frame within which it was being done and the implications that it will have for government's finances when we take over. It was fair that the government side share this with us and allow us to review it together so that we know exactly where things stand. Now, this was rebuffed despite our entreaty. So you recall that on 17 December 2024, I issued a statement on behalf of the incoming government side of transition, indicating that we were going to review these processes and look into them to ensure that they complied with due process. True to that, in February 2025, the Chief of Staff issued a directive that all those who were recruited within that period should have their appointment revoked pending investigations. Shortly after that, we also received a significant number of petitions from people who said that, as far as they were concerned, they had gone through due process to be employed, and yet they had been affected by this directive. So the Chief of Staff set up what he called a revocation committee, made up of representatives from government, organized labor, and other important stakeholders. We read out their terms of reference, so there's no point belaboring it. Now, in order to determine whether an employment, recruitment, promotion, or appointment was lawful, about 8 to 9 steps should have been followed. The first is that there should be evidence that the vacancy was declared. The vacancy was declared for everybody to know that there was such a vacancy. Number 2, it should be advertised in daily newspapers and other media. Number 3, there should be an approved scheme of service which determines who does what and what the organization structure looks like. We should have what we call technical clearance. Then financial clearance, which means that government should be in a position to pay, or government should indicate its readiness to pay the person once employed. Then there should be an interview, some screening or vetting process to determine the suitability of the individuals for employment. And then you are issued an appointment letter if you are successful, and then you indicate your acceptance. In some instances, if you had already been employed, you can show a pay slip. That is, if you started receiving payment before the work of the committee. So, in all, about 36 organizations appeared before the committee. Together, they showed that they had revoked the appointment of 2,080 people. So the committee looked at each case with a fine comb, went through it, and found that 1,201 of such cases should be reinstated because they went through due process. They met all these requirements. Indeed, what the committee said was that if you met 80% of these 8 to 9 requirements that I've just highlighted, you could be given a pass to continue. So it is possible that they may not have declared a vacancy or that it would not have been advertised. But at the very least, there was financial clearance, there was technical clearance. You went through some vetting process. So 80% of it is fine. Those who did not meet this threshold were the ones whose appointments were revoked. You know, like I said, 879 should have been affected. But we had to give some special consideration to persons living with disability who were predominantly in the education sector, in order that, because of their peculiar circumstances, they do not suffer. And then 534 or so were asked or had their appointments revoked. So this essentially is what it is. It is a reflection of government's desire to be fair and principled. Again, let me indicate that this was not done with malice. It had no political motive whatsoever, because indeed we could not even determine the political collaboration of any individual. Nobody requested that anybody show where they belong in terms of the political divide. But it is necessary that we do the right things. In fact, I recall that in the 2017 transition, the NPP side, in fact, demanded similar regard. I recall Mr. Osafumafo, who chaired the side of the transition team, insisting that all payments should be put on hold and that no such recruitment should be done. When we requested him, we were told that the government's mandate did not end with the election. That is true. But given that the transition period is so short and an incoming government was coming in, and that recruiting people has an impact on the wage bill, which the incoming government has to foot, it is necessary that this is done transparently and that we know what is happening. So perhaps going forward, we should incorporate this in our arrangements to make sure that we don't go on this route. It does not help. What you need to do is to indicate it in your transition law that we started the process. This is where we are. This is the criteria that has been set. This is the number of people who have applied. This is the process that we've gone through up to this stage. What do you make of it? Or you may want to continue. Because mind you, the incoming government comes with its own priorities, its own set of, its own agenda, and its own set of expenditure patterns that it believes will help prosecute the very commitments that it has made to the people of Ghana. So for me, in a nutshell, this is what it is. A straightforward, fair, just process that has been undertaken to uphold the rule of law. The time of the completion of the job or the release of the
committee's work appears to coincide with a decision of the Labour Division of the High Court, where even though the conclusion was a consent judgment in respect of the Ghana Maritime Authority, where some people who suffered this had, been sort of reinstated, about 9 of them, as we understand. Is this intended, because we know many of them had taken the matter to court, is this intended to preempt?
Oh, not at all. There have been legitimate public inquiries about the state of that investigation, the state of that committee. So I have received many in my capacity as a Minister of State for Government Communications. And at some point, we're always going to go to the public with the findings. That was all it was intended to do anyway. It's also imperative that people are not kept in abeyance. People are not kept in suspense, because this is about people's livelihoods.
That's right.
People look forward to obtaining employment so that they can earn income. You cannot keep them perpetually in the state of abeyance.
Right.
Again, as for that, people will go to court. It is your right to do so. If you feel aggrieved by any act of government, any act of any state agency, you are free to go to court. Once the court rules one way or the other, government has no option than to comply with it, unless, of course, we have strong basis to believe that we can seek judicial review of that. Let me also clarify, because since I presented the report, these questions have come in. People have sought to find out, so what will happen after this? What will simply happen is that the organizations that are concerned will write to the individuals concerned, both those who have been reinstated and those whose appointments have been revoked, telling them clearly why it is so. If anybody feels aggrieved, they are always allowed to seek redress elsewhere. And once a binding ruling is made, government will be bound by it and act accordingly.
All right. What is the minority talking about now? Feeling some vindication that you were saying these things were wrong in the first place? Is that the conversation you are having? Or you are being practical about it, being sincere about it, and say some of them were unwarranted? You wait till the last minute, you are moving out, and then you try to saddle an organization with a number of employees. There's no budget line for them. And we've seen, for example, teachers go on demonstration that they've not been paid for a year. And we are also being told, but there was never a budget for this.
Yeah, so the position of the minority has been clear that we do not in any way support impropriety. That if processes leading to recruitment of persons were found to be inappropriate, we cannot be seen in the spirit of the laws of the country to be supporting, quote-unquote, any illegality, especially so when said recruitment process is supposed to be open, transparent, to give every Ghanaian an opportunity to be recruited. However, we were fortified in our position because we were of the view, and as events have come to vindicate us, that the whole directive was wrong. It was self-inflicted, and then the chaos that it threw these particular supposed employees or young Ghanaians into was unwarranted, because you could have even achieved the same objective without necessarily issuing a directive in the brazen manner in which it was done, showing a complete use of government power to show that, okay, we will do as we like. But let me first and foremost note that the outcome of the committee's report, if it's what Mr. Felix has told us, is what transpired. To a great extent, I would say it is fair that people were given opportunity to be heard. Those people made their case before the committee assessed the criteria and came to a very transparent and a very acceptable determination of the issue. So to that extent, I'll commend the committee. But to start with, it was not necessary. They could have actually achieved the same objective without necessarily going for. You see the cost of what they have done? Apart from saving the country of some 500 people, they have also allowing some 1,204 persons or more to sit down at home without doing anything, and they're going to get salary for 1 year. That's the meaning of it. You see, but these people could have been contributing to the national economy. They could have been contributing to the workforce whilst these processes are going. And if it's found out that it is legitimate for the period that he has worked for, you could have, even if the employment was illegitimate, probably, you could have actually demanded that the basis for the employment was not good, so you are not entitled to anything. Those parameters could have been determined. So I think that this should be a lesson to all of us, politicians, that when you get power and you feel that there's something wrong with recruitment. They say that there's something wrong with any sector of the country, that after elections, people are rushing and scrambling to take certain positions and to take certain resources of the country, that you feel stronger about it. You must do that within the lay-down procedure, mindful of the fact that any decision you are going to take is going to incur a cost, or there's going to be a cost element to the state. In any case, I want to note that the minister is clear with us today that only some 534 or some 541, about 541 people have not got their jobs back. And the criteria or the reason why they've not gotten their jobs back is because these processes commence after December 7th, 2024. That's the end. And also because they didn't follow the lay-down processes for recruitment.
Exactly.
This is the only criteria that will make anyone not qualified to be called back or to be reinstated. And I think that this brings clarity to everyone out there who is still of the view that my appointment is terminated. For all those who had their appointment letter before December 7th, means that they are automatically qualified or reinstated to the extent that they follow the lay-down processes. But it's clear that it is only those who got their appointment after December 7th, and then they did
not show evidence where there's no evidence of a declaration of a vacancy. There is no copy of an advertisement. There's no evidence of advertisement of the vacancy. There is no evidence of approved scheme for the service. There's no evidence of technical clearance. There's no evidence of financial clearance or evidence of interview or an appointment letter or an acceptance letter.
Let me clarify, just for the benefit of, I'm sorry that I have to interject. There are those also whose processes started before December 7th, but did not conclude before December 7th. For instance, you know that financial clearance takes a bit of time to get. So when they got to the financial clearance stage, it dragged. You cannot fault them for the delay. Those two were considered to be legitimate and were reinstated. But it is those whose processes started after December 7th. Or who did not go through due process, no matter when the process started, who have been affected. But this has been done to correct a systemic problem.
Yeah. So that even if the process started after December 7th, and there is evidence of a declaration of a vacancy,
there's evidence that due process,
there is advertisement of the vacancy and all.
Indeed, that is what we were asking for.
All right.
We're never saying that you cannot employ after December, but don't rush it and circumvent lay-down rules simply because. All right. That you are living a spot that.
Okay.
Yeah. So there is.
I was thinking that the other side of the caution that you may want to give to people in public office, I'm talking to Doc, will be that always comply with due process, especially when you are doing this at the last minute. You've lost power, and suddenly the people you couldn't find jobs for, you are trying to find jobs for them before you exit.
Yes, I mean, I agree that. The fact that 2,200 people went through the process vindicate the point that the picture they were creating about this whole issue was wrong. Because they created a picture that every single person of the 2,000 persons were actually recruited without following due process. And I think that once you create that picture, it becomes political. And people will find way back before elections. And in 2025, when I can make reference to the health insurance, they came to office and they terminated such appointments. Were those appointments part of the general 2,000? In any case, but those who the institution themselves have issued a termination letter to that effect, are they also now going to issue reinstatement, withdrawing their previous letter, terminating their appointments? Because these are not even, those were even period way before the election.
You are suggesting that there are people who are affected who are not part of the 2008 or so that went through the investigation, 2080 that went through the investigation. Is that your suggestion?
Yes, I'm saying that there were some persons who were not employed even in December. They got their employment.
I got that.
Yes.
I got that. But all I wanted to establish is that this committee looked at 2,080 recruitments. Appointments and promotions, right? And out of that number, 1,539 have sailed through.
Yes.
It is only 541 who have suffered a revocation.
Yeah, so what problem?
It is 1,201 who met the criteria. The
338 was just because of their status.
That one must be. I guess it's assumptions who are probably to determine the time frame they use, whether they included November.
No, November. Again, if I may clarify for the benefit of Kabiru, the Chief of Staff's directive said any sort of employment after 7th December.
Good.
But I indicated that after that directive went out, we received petitions from persons who said that their appointments predated 7th December, yet they have been affected. That is why the Chief of Staff actually set up the committee, so that people do not act with impunity and victimize others unfairly.
All right.
That is all that this committee.
So you see, there is the minority. That means the minority concern is still legitimate, and that this report has not finally addressed that.
Which one?
Because there were some people whose appointments were withdrawn, and they were even in excess of the directive of the Chief of Staff. We drew attention of the country to that.
Yeah, so any directive that has come to the attention of the committee has been dealt with. Unless, of course, it hasn't come.
So that's the point I'm making. I'm making the point that the terms of reference of the committee was the fact that any appointment that was done, say, in December.
Yes.
And I know for a fact that people were employed in November. When this directive was issued, CEOs and MDs of the various MMDAs that were affected in this particular program actually issued termination letters to people, relying on the Chief of Staff's directive. And we even drew the attention to the fact that, look, you are going in excess of the Chief of Staff's directive.
Yeah, Fiyama has been stating
has been saying that.
So if that has happened, it is most likely to have been corrected by this exercise. But of course, let me also indicate that if there's anybody like that who has suffered unfairly and who believes that their appointment predated December 7th, who has not heard from the institutions or this one, they can bring it to the attention of government.
So I'm happy with the assurance, given that they can, and I will be very, about qualification as of war, and the minority in general is helping solve this thing. We would bring that to your attention. But you see, that until that happens, we are still having some challenge. And let me come to the 500 people. Look, with the greatest respect, minority will never support any person who is employed when the freedom processes have not been followed. But can the committee probably get us to know that those institutions involved in this particular, so in the interest of transparency or in the interest of full disclosure, we know the respective institutions that actually went beyond trying to recruit those persons when elections had been declared. In any case, there's nothing wrong with recruiting people after the end of election, because the institution going concern, the institution will go beyond the political power. The politician.
So there's a list of 36, institutions.
I listed all of them.
Yes, that was given. So it's already out there.
The list of 36 institutions are those who appeared.
Yes,
as he said.
Exactly.
But of those who appeared, out of the 36, which of them were disqualified? We don't, based on the basis of this particular criteria, because they are institutional recruitment. And it's not the individual who is initiating the recruitment.
Your question is that for the revocations,
exactly,
we should ask.
Let me just conclude on this point that, look, the lesson we are learning is that government should not do things in a manner just because there's a change in power. You are trying to put people into the payroll without necessary approval. That's the first thing. The second most important lesson is the characterization of such recruitment as unlawful, and then the decision to proceed on that basis to terminate them. And that decision by the government to terminate this contract has caused the nation losses. And I think that these losses that it is causing us could have been avoided by the fact that the government could have decided to hold on with the process, institute inquiry, and tell that those people report to whereby when we've determined at the end of the day that your appointment was unlawful, we terminate it. And I think that was been the decent, the conduct with which they would have done it would have been.
All right.
So our position is that, look,
from where you sit, this committee should have preceded the dismissals.
Exactly.
Okay. A couple of messages here. Someone says that my niece was appointed in September, had received her salary for September, October, November, and in December, but was sacked in January 2025. So it's not true that those sacked were employed after 7th December. Okay, so there's a miscommunication. You are not getting.
They will call some of them back. So
exactly. Right. So those who have been found to have gone through due process, what Felix says is that they will receive notifications to resume work. Those who have also been terminated will receive notifications to that effect.
And as of today, there's no information as to whether they have issued those notifications or not. So
the institutions will issue
do that. As far as I know,
but they have not done that.
But let me also stress that if there's anybody who, within a certain reasonable period of time, does not receive information from the institution regarding whether they be reinstated or revoked, they can always draw government's attention. It will be looked into, and then to the extent that what they are saying is true, it will be undone. Yes.
How do they go about that? Drawing
also, you can write to the Chief of Staff's office. You can write to the respective sector minister.
Okay.
Then it will be, or you can even write to the institution again to ensure that you bring it to their attention.
This one says, concerning Felix's Meet the Press about those appointments that were upheld and revoked, there is one question people want to ask: how does anyone who got affected check or know whether they belong to those whose appointment got revoked or upheld? Can we have Felix give further detail? Okay, so this has been answered. Even
the last issue that probably I would want, maybe we are learning, but you see, all these things are happening to right.
Oliver is waiting to
speak just because Felix had issued statement in the past to the effect that appointment after December 7th cannot be unlawful. When President Mahama made certain appointment after the election.
No, but those are not unlawful. So, that's unlawful.
No,
you can say that
any appointment after 7 December cannot be unlawful. The only unlawful part is the due process.
Yes,
exactly.
And that's the point. I
stated that.
Yeah, I think that's the point that we need to. But because there's a precedent to create a sense that any government that does employment or initiate employment after December 7th is unlawful, we should correct that.
And then also, I think that it is fair that the incoming government is made aware and apprised of the status of these things, because it is important for planning.
All right.
Yes.
All right.
That essentially is a government.
Well, let me move to Oliver, but someone also had a question for Felix about the CRC report, Professor H.K.C. Prempe Committee report. She wants to know.
So there's an implementation committee. I think the membership has even been determined, but we are just tying up a few loose ends. So very soon it will be announced and they will start working.
Okay. You are.
You know that because it is a committee, there will not be any white paper. But government will state a position on what it accepts, what it disagrees with, and what government thinks should be done. Then the committee will be announced to start implementing the recommendations. Those ones that government agrees with. Yes.
Thank you. Yes. Oliver, what do you make of these matters, particularly that seeing that you've been in court trying to, assert the case for people who have also seen themselves in such circumstances?
I think now my philosophy now is that when in doubt, look at the Kwesi Prempe report, to be honest. Because as Felix said, this is something which is, systemic and has continued to bedevil our politics for a while. One of the things that they looked into was the question of whether or not there's any constitutional evidence of other countries which have faced similar problems as us, and how have they dealt with it. So they look at, for instance, the Philippines, and they saw that in Philippines, 2 months before the presidential elections, the presidency or the government cannot make any appointments for 2 months. The only exception is that where it is necessary to prevent serious disruption to the public service. And those cases are very limited as to when appointments can be made. They also look at the Kenyan constitution, which goes even a bit further. And from when voting starts to the next president assumes office, you cannot make any major appointments, including judges, ministers, or anybody exercising executive powers. Even the granting of pardons or national amnesty cannot be made after the vote has occurred. So they have looked at this. They knew that these issues have come up in context of our transitions, and also made recommendations in that regard, where they are saying that we should also institute a similar constitutional mechanisms where once the transition period begins after the election, there will be no appointment or offer of appointment to a public office if that appointment extends into the next administration. So what that means is that if the presidency or any organization needs to make a short-term appointment for the next month, then that's fine, because it doesn't extend into the next administration issue. However, where there are questions about it extending, or there's new contracts or wage increases or certain financial commitments, then it will only be valid if it is in line with the current year's appropriations. If there's no appropriation mechanism for it within that year, it will not be valid. It is void ab initio. They're also prohibiting the sale of public lands and public assets during the transition period. So it's mopping up some of the historic concerns that people have had about we typically see that happens across the board. And I think that provides us a framework for also reviewing the Presidential Transitions Act regarding how we deal with this problem. There's something which is important also, that when we're having this conversation, we must bear in mind. The vast majority of these situations affect young people. And for me, I do not care whether or not they belong to Party A or Party Z. Young people have to be treated fairly in terms of how we avoid these political baskets and playing with them. Their lives are stakes. There are people who have ordered their lives in a particular way. Some travel, hire, rent apartments and things like that in anticipation of employment. They need to be treated better and within a predictable framework. And I hope that legislation and constitutional reform can provide that predictable framework with how we deal with these things going forward.
You know, we had to do a transition act to sort of get the politicians or the political leadership not to do certain things. Now, by the Constitution Review Committee's recommendations, we are going to constitutionalize, the prohibition of some of these appointments or employments in the dying days of a regime. Do you think that we have been told that in this country we have good laws? The problem has to do with the implementation. Do you think that will still be a challenge?
I hear that often. I do think that a lot of the times the reason why enforcement becomes a problem, and we haven't theorized or created think tanks to think about the implementation gap of our laws. A lot of this happens where the laws permit discretion. And sometimes discretion is inevitable because you're hoping that the circumstances of the situation would allow flexibility. But it is in those margins where we are the most abusive of law. What we're always looking for is black letter. If it says no, then we say, okay, fine. Then we have to. And it's almost like treating the political class as if, excuse my language, as if they are children, where it's like, we can't trust your judgment. We can't even give you the basic margin of error to be able to act in good faith. That constantly, we have to then create these mechanisms of blanket yes or no scenarios, because outside of that, there's always an opportunity to abuse. And I think that sometimes when the problem becomes so systemic and endemic, it becomes the only way out of it, that the clarity of our rules are important. We see the same thing happens in terms of implementation of whether it is natural resource, mining concessions, any part of our law. Anytime we have set an institution in place, we then create a ministerial discretion on top of that framework. And that ministerial discretion then consistently leads to abuse. And this is something which we haven't gone back to revisit our drafting guides to think about the implementation problems of laws more generally. We haven't thought about how we insulate and how we use Article 296 framework to better bolster the exercise of discretion. So because of that, the administrative state itself is not better thought through, it's not better rationalized in order to prevent abuses. Now, I have come to accept that we have a political class that needs red means red. If you go and put a yellow light there, people are going to drive through the yellow light. So if it is red, it is red. If it is green, it is green.
Right.
Perhaps we have peace of mind in that
Right. So on that note, I like to go over the recommendations that the Constitution Review Committee made in respect of, post-election appointments. And for those of us who haven't found time to read the document, please read it. It's very important so that it guides some of our commentaries sometimes where we say things that are right in there, but because we have not read, we seem to suggest that nothing has been done about it. Something has. Now, we as the people must tax this government and ensure that they implement this. Make sure that the recommendations are passed into either by Parliament or through a referendum. At 1.94, the committee recommended that, I read, the committee recommends an amendment to Chapter 8 of the Constitution by the introduction of a new provision to forbid or prevent the taking of certain specified actions by the President or a member of his or her government or administration within the transition period commencing from the date of presidential election to the date of the assumption of office of the next president as follows. A. No appointment, nomination, or offer of employment to a public office may be made or extended to any person, the term of which would extend into the next administration. B. No new contracts or commitment, including a salary or wage increase, may be granted or offered that is not allowed, that is not already approved in the current year's appropriations. C. No transaction for the sale or purchase into or purported to be entered into in violation of any of the above provisions shall be deemed to be void and would impose no obligation on the state in favor of any third party. This is how clear you want it to be, right, Oliver?
Absolutely. The thing has been even more clearer in connection with this issue. And I do think it will solve it. But the process of governing also brings up so many other issues. And I think that my hope is that at the end of the constitutional process, and the committee that is being put in place, its mandate will extend beyond not only translating the recommendations into constitutional reform, but also the post-constitutional adoption audit. Because so many of our laws need to be re-audited to realign. And we have to be able to have a categorical look at this. We haven't done this in the past. Even when we adopted the 1992 Constitution, we just gave validity to the range of PNDC laws and SMCD decrees and so many of them that should have been reviewed to be able to determine their continued constitutional compliance. This is something that I think maybe the Law Reform Commission even can take on to be able to determine, with the new reforms that have come into place, what the body of all our laws need to change, and particularly how do we reconceptualize ministerial and executive discretion going forward.
Thank you very much. And this is where we draw the curtains on this particular subject. I'll take a next break and return to the issue of parliamentarians. Should they be riding in 4x4s or we should give them bicycles? You remember Ras Mubarak riding the bicycle to Parliament and getting so much support for it. But Felix, you said if someone was affected and they don't receive a communication or a notice from their institution, they could reach out through to the chief of staff or to the sector minister or write to the institution itself. Okay, because I've got some lawyers who are saying they represent some of these people, but they don't know as yet if their clients are some of those who have received exoneration, because they expect exoneration. Yes. Looking at the criteria that was used by the committee, which Dr. Kabiru admits, any fair-minded person will admit that the process was fair. Yes. And so we expect that we're doing with... You know the Communications Ministry, St. George issued that termination. Yeah, so people are thinking about all of
Exim Bank.
I know about that situation. For example, there is this particular agency under the Lands and Natural Resources where people were recruited properly back in 2018 and 2019 who also suffered. Yeah,
so if you are affected, like, as I said, just indeed, like I've been at pains to stress all day, the setting up of this commission was triggered by the receipt of such complaints.
All right.
That there has been some unfairness or ill treatment of people, and that people had gone beyond the cutoff point of 7 December. Right. So if you are within that bracket, just send a petition to any of these quarters that I have indicated, and it will be looked into.
Right. Yes. So my guests have been Dr. Kabiru, who is MP for Wale, Felix Kwachio Fosu, who is Government Communications Minister, also Oliver Bakavomawo of the Democracy Hub. Bright Simmons joined us earlier for eye care service provider for 33 plus years. And talking about Chelsea University, please, government needs to pay attention to the road there. It's so terrible, whether it is the time where there is dust or it is raining is very terrible. And the people who live around those places are all complaining. We need to pay attention to that place. My Way Insurance Dial star 165 hash on MTN to join my way today. Syntex Tanks is strong, it's tough. Safari Valley Eco Park, bringing you closer to nature. And there's an ongoing promotion. You want to take advantage of it and take some important and refreshing relaxation at Safari Valley Eco Park. Gold board jewelry, pure, precious, proudly Ghanaian. Koa natural juice, 100% cocoa fruit juice. Malcolm, your #1 shopping destination. Waylead, your trusted home builder. And Bethel Dental, the smile starts here. We will be right back.